in order to prove that someone is, guilty beyond a reasonable doubt of being under the influence of marijuana, the DA, the prosecutor in Marin County, has to be able to show that someone was, one, driving, and while they were driving, that they were impaired by the drug that they're under the influence of. So under the influence means not driving with the care and caution of a sober person. And in order to prove that, they'll use different things. Typically, there's a blood test. And so while there's no per se number, they will try and show that there was a good amount of active marijuana, THC, the active ingredient here in your blood. And they'll bring in an expert witness to try and do that. They'll bring in a forensic toxicologist. Typically, they bring in one who did the test from the lab, the Department of Justice lab up in Santa Rosa. And that would be if the case went to a jury trial. They would bring in their witnesses for that. The other types of witnesses that they would use would be the police officers, or they might bring in people who observe bad driving. Now, the officers would talk about the driving. They talk about the field sobriety test, their observations of the person who was arrested for the DUI. They would go into, they would get questioned about, what they saw, what they smelled, what they were told by the individual who got arrested or others. And then the other thing that they will do, and this is something that they should be doing in every DUI case, but they don't always do, is they should have, it's usually a CHP officer who is trained as a drug recognition expert. And they should have what they call a DRE evaluation, where this expert evaluates the person who is supposedly under the influence of drugs. In this case, it would be marijuana. And so they run them through these 12 different steps of, a test that has been designed by, those that are supposedly in the know to help determine whether or not someone is under the influence of the drug they're being evaluated for. This is very rough science. It is very tough to prove that someone was under the influence of marijuana unless they've got, horrible driving, an accident that was caused by the horrible driving, and then a number of other things going on. You put it all together. The prosecutors, the district attorney's office in Marin County would much rather bring a alcohol case, because they not only get to, try and prove someone was impaired, there's another charge that they get to bring, which is the per se 0.08 blood alcohol level charge. And they'll have scientific evidence of that with exact numbers. And if someone's an 0.08 or higher, they've got, those numbers on breath tests, blood tests. It's much easier for them to prove. So they don't like the marijuana cases because they're tougher. They make the prosecutors work harder. And it's just proving what's impairment, what isn't. It's a very, very, foggy line. And because the burden of proof is beyond a reasonable doubt, marijuana cases are often very tough for prosecutors in Marin County to get convictions on.